maintenance of international peace and security. The international community had the confidence to create a permanent rather than an ad hoc court. But I think one of the first challenges we need to recognize here is that even though it's a permanent court, it's a consensual court, and not all member states are part of it. So it's a challenge to institutions like this International Council of Jurists to try and work towards ensuring that the system of justice becomes universal, that all states, even though most of them are in ICC, but that all the remaining states as well become states parties to this Rome Statute of the International Criminal Court. And in that way, then, we can really have a truly universal system of accountability for all persons under the law. So long as big actors, big states, which choose to operate outside the ambit of the Rome Statute, then we will have a situation where some are subject to the law and some are not subject to the law. And that is not. And that, as Lord Delhi would have said in another situation, would be bad for both. That's one of the challenges we face. We also have to recognize that even though international criminal justice process is good and is necessary, because of the limitation of numbers that it can deal with, we must try and give concrete realization to the principle that the primary responsibility for prosecuting these sorts of offenses, genocide, war crimes, crimes against humanity, terrorism, trafficking, and so on, the primary responsibility rests with the nation state. And the international process is a process of last resort to deal with those cases that the member states cannot or will not. This too has its implications. There are many states which are able to prosecute these kinds of cases, but they are not willing. There are some that are willing, but they are not able. There are some that are both able and willing. You have all those three categories. And we have to work towards ensuring that those that are able are also willing. That is a political problem, usually. They are able, but politically they are unwilling to prosecute. It's a political problem, a political challenge, and we need to ensure that in each state there is a political will to prosecute all persons, irrespective of their status, when they engage in these serious violations of humanitarian law. There are others who are willing but not able because either their legal framework is inadequate or they lack the capacity to undertake these sorts of proceedings. And here, the challenge is to make sure that those states have the capacity to do that. The starting point was law reform. We spoke earlier this morning about accountability and law reform. And it is as relevant as it was in the morning as under the issue that we are now discussing. The starting point needs to be law reform. We need to domesticate all these serious international crimes within our own national laws. Make sure that they are also crimes. But I think we need to go beyond that. We need to give legal effect to the principle of being our neighbors and our brothers' keepers. When a nation state seeks to enforce international criminal law, it should not limit it to only crimes committed within its own territory. Every state should give itself the legal capacity to prosecute persons who come within its territory for offenses committed extraterritorially. In other words, offenses committed outside your country should be punishable, because these are the kinds of offenses which are so gross that they should shock the conscience of mankind. So we cannot make distinctions and say simply because this was committed outside our territory, if the offender finds himself in our territory, he will be able to enjoy safe haven. That would be wrong. So in engaging in law reform, we must insist that not only we domesticate these offenses, but we give all our courts a universal jurisdiction to prosecute these kinds of offenses wherever they may have been committed, so long as the offenders find themselves within our territorial limits. Beyond the issue of law, of course, there is the issue of capacity. These are kind of very technical, very special offenses. And investigators, police, court officials all need to have training and the capacity and the understanding in how to manage and deal with these kinds of offenses. And And I think in all these three areas, private organizations like the International Council of Jurists have a unique opportunity to bring some influence to bear on member states so that they can move in this direction. If we do end up having a rule statute which is truly universal, with member states which have adequately reformed laws, with member states which undertake to exercise universal jurisdiction to punish people for these crimes, even committed outside their territory, then I think we would have succeeded in ensuring that there is no safe haven for anybody who commits these serious violations of international humanitarian law. I'd like to thank you very much for your attention. When I resume my seat as chairperson, I'd like to invite questions and comments. I think we still have time for that, Mr. President. We still have time for questions. We have 5 minutes for any questions or comments that anybody wishes to make. Yes, sir.
Yeah, you sir just mentioned about the international, that genocide, international crimes and all this, there was a tribunal. Now, I would ask the question to Mr. Kedman, that if there was no due process of law in setting up International Crimes Tribunal in Bangladesh, how it was called Independent International Crimes Tribunal A, and if there is no due process, how can he represent them there by the defendant, and he is going there to defend all the collaborators who committed genocide in Bangladesh, which you know in 1971, thousands and thousands of innocent people, children and women were killed, massacred and raped. And rape on Bangladesh is a history there. If these people, as you say, De Silva and others, you will know as a prosecutor, it's a very big job. But their children and grandchildren wanted to know what happened to these killers who killed. They are the local agents. They're the local agents who deliberately targeted these people, and they killed, raped their women and children, and it's a genocide and crime against humanity was committed in Bangladesh, soil of Bangladesh. Is it not a right of any country to trial them, to bring them into justice? That's the question I want to ask.
Thank you very much.
Referred in his speech to something known as Pakistani occupied Kashmir. Being a Pakistani Kashmiri, I would like him to elaborate on that phrase.
Very quickly, I am not a Bangladeshi government representative. I'm a British Bangladeshi, and I asked the question as a British Bangladeshi. The question is to Mr. Toby Kaplan, and I'm surprised that a person who is going to be representing the defense in the war crimes issue, which is such a sensitive issue, which has been for the past 40 years of Bangladesh, for the first time this issue is going to be addressed, because there is a political will and there's also citizens' will. And the perpetrators have evaded justice for the last 40 years. and the Bangladesh government has been painstakingly, as far as I know as a British Bangladeshi, to try to bring a forum which is internationally accepted, because it needs to be internationally accepted, otherwise there'll be issues around it. The current government, if it could have straight away started with the trial, and it did not, specifically because it was taking into consideration what the international standard, it had to confirm the international standard. The 1973 Act, which we have disputed, has been on various occasions praised as a very good structure to have the war crimes held in Bangladesh. Very few nations have an act of themselves, and Bangladesh is very proud to have the 1973 Act. And we have set up committees in order to amend it and bring it to international standard, as far as I know. Now, the level of commitment for the Bangladeshis, for those who are present here, is not only from the section of the government, but generally the public as well. One such example is, 2 years ago in the House of Lords, what the Bangla Carta 21, which is actually a forum which discusses pertaining social and legal issues concerning Bangladesh, held an international seminar inviting lawyers from Canada, from the United Kingdom, from Switzerland, from Bangladesh, from India, to discuss specifically the war crimes issue. And there it was discussed with experts at length, and it was found that the 1973 Act actually was a suitable act through which the trial could be conducted. So I'm surprised that in a forum like this, a defense lawyer can put his client and the issue in such an unfair way, and I'm surprised that there was no scope for any Bangladeshi representative, either from the prosecution team or from the government, to actually address this issue. As a British Bangladeshi, as an advocate myself, as a solicitor, and as a researcher, I find it absolutely appalling. Thank you very much.
Thank you.
Thank you very much. Now, thank you, the panelists.
From the concerned person, because actually I invite, if somebody want to make a point from Bangladesh side, I invite them, any one of them, to speak, but cross-examination and this thing I think will be not appropriate. It will develop. So it is better if you can speak for 5-10 minutes, present your case instead of making query, because everybody has his own right.
I'm very sorry, I'm intervening again.
Everything that you've said is correct. There should be a tribunal to deal with these matters. And every time I've spoken on this issue, I've said Bangladesh has a responsibility to hold those responsible accountable. I fully agree with that. The point that I've tried to make, and I've not targeted the tribunal, I've not attempted to criticise the tribunal, it's the procedures that I have spoken about today. I've said the procedures do not meet international standards, and if it's going to be done, it has to be done properly. And I am not opposing the tribunal in any shape or form. I'm only requesting that it be done properly. That's all.
Now, the question from my learned friend is, occupied Kashmir. There is a line of control and actual line of control. There is a line of control and actual line of control. Aggressions of 1971. Number of refugees came from the occupied Kashmir. Now that area is now in Pakistan. I say some of the seats of the assembly are still reserved for that area. Now we have 84 seats out of 100. 16 are still reserved for the area which is now in the occupation of the Pakistan. Now it's a dispute between the two countries, India and Pakistan. There is a line of control and actual line of control. Now the person who has migrated from the actual line of control